Is racial profiling grounds for an exclusion of evidence in an Oklahoma prosecution? I'm Tulsa Attorney James Wirth, and that is the question that we have. If we have, so say Fourth Amendment rights violated, Fifth Amendment rights violated. Say you're driving down the street and you're pulled over without any reasonable suspicion or probable cause a crime is being committed. You've been unlawfully detained against the Fourth Amendment. So what is the remedy for that? Well, the courts have determined, and it's long been the case, that the exclusionary rule is the remedy. So any evidence that was illegally obtained based on that illegal stop is not admissible into court. That is a very good incentive for law enforcement and prosecutors to ensure that they are acting properly. If they can't get any benefit from their bad acts, there's no incentive to do so, and that prevents cops from committing bad acts. That's the idea. But if there is racial profiling going on, can you apply the exclusionary rule to that? Well, Oklahoma has a statute that specifically bans racial profiling. It was just came into law in the year 2000. It's Title 22, Section 34.3. If you look at subsection B, it says no officer of any municipality, county, or state law enforcement agency shall engage in racial profiling. So right there, it makes racial profiling illegal. Obviously, there's also arguments that it's unconstitutional under the United States Constitution and the Oklahoma Constitution as well. But it doesn't talk about, at least in that section, any kind of remedy. So if you can demonstrate the officers pulled you over and you were stopped simply based on your race, but then there is alleged contraband that was found, can you file a motion to suppress that evidence because it was obtained against this law? And the Oklahoma Court of Criminal Appeals has looked at that recently. And this is an unpublished case, Fletcher v. State of Oklahoma, F-2021-1319. And what the court essentially finds is that the courts have found that the exclusionary rule is not the appropriate remedy for selective enforcement violation or racial profiling. So even if you can establish that it was racial profiling and there should not have been a stop and it was illegal, this court is not going to provide you any relief on that in the criminal case that resulted from it. What they say is that observing a criminal defendant victimized by racial biased pretextual stop can claim a violation of Equal Protection Clause in a separate civil proceeding. So essentially they're saying, yeah, they're still going to prosecute you. The officers that broke the law still get the benefit of any evidence that they obtained, even though they obtained it illegally in order to get a conviction, try to throw you in jail. But you can try to hire an attorney and sue the government in a civil rights proceeding that could take, more money than you're likely to have to put into it, and for a potential judgment that's going to have very little value to it, so that an attorney would take it on a contingency. But you've got to essentially prove that in a civil court on your own. So that's not the best decision that we'd hope if we want to avoid officers engaging those sorts of activities. But that is the current state of the law in the state of Oklahoma pursuant to the Oklahoma Court of Criminal Appeals. All right, so if you're dealing with an issue like this, you need a defense strategy, talk to your attorney about that. You want to talk to somebody privately and confidentially in order to receive specific legal advice. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.